Hello, everyone. Thank you for joining us. We'll just take a moment to let everybody get in. So we're going to get started here momentarily. Thank you for joining us.
It goes up slowly.
Yeah, it's still jumping though. So we'll just give folks another, maybe 30 seconds before we start. So thank you for joining us here today. We really appreciate you being here. Okay, it looks like it's kind of slowing up for the moment. So I suppose we could get started. Welcome, everybody. Thank you for joining us here today. We really appreciate you spending a portion of your day to hear us talk about what is a very important issue. It's been, I think, an important issue for some time now. Um, Often gets overlooked in the busyness of life, but at the end of the day, on some level, it really is all about patent quality. Judge Rich famously said, "The name of the game are the claims." I think, if he were alive today, I think he would probably amend that to say something along the lines of the name of the game are how are your claims quality based? Because just collecting claims and just collecting patents is really not enough anymore in a world where you have the PTAB, you have efficient infringement, you have a lot of the rights are going against patent owners. A lot of the laws are kind of, I think, a bit skewed. Whatever your version of the universe is, I think everybody has to agree that patent quality is today more important than it's ever been. So that's the conversation we're going to have today. We appreciate IP.com sponsoring this conversation, and we'll talk a little bit about where they fit into this as we go through. But Renee, maybe we could start by introducing the speakers and we can go from there.
Sounds good. All right. So today on our panel, we have Savon Kalmanov. He is the director of Canon USA IP Division, where he oversees both the patent prosecution and administration departments. He also provides support on patent litigation and contract matters and general U.S. patent law related advice to various domestic and international Canon companies and subsidiaries. He is a current member of the California State Bar IP section and a past chair, vice chair, secretary, general executive committee member, and patent group chair of the section as well. In addition to his JD, Sivon also has a bachelor's of science in electrical engineering. Next, we have Clint Mehall. He's a partner with Davidson Capel LLC. He has prosecuted hundreds of U.S. patent applications in multiple technology areas and has filed over 100 appeals with an exceptional win rate at the USPTO Patent Trial and Appeals Board. He also has experience collaborating with foreign attorneys in Europe, Japan, and China, as well as litigating patents, post-grant proceedings, performing patentability searches, and preparing infringement, validity, and freedom to operate opinions. Currently, he serves as the co-chair of the New York IPLA's Patent Law and Practice Committee. Next, we have Chris Tones. He's a solutions architect at IP.com, where he works closely with their product line management and science teams to gather and implement customer feedback, prioritize feature development, and support upcoming releases. He also supports the sales team with technical demonstrations and trainings with a particular focus on utilizing the IP.com suite of solutions to help partners identify and impact crucial IP-centric KPIs that drive ROI within their business. Next, we have Jim Durkin. He is a former US PTO patent examiner and managing director of product management at IP.com, where he works directly with clients across the globe and the company's development team to enable AI-assisted workflow solutions related to IP.com's insight reports, as well as their innovation discovery and AI-driven search platform, Innovation Queue, and its flagship prior art database for defense publication. He's a registered patent attorney, inventor, and former primary patent examiner for the USPTO in the area of graphical user interface, and he also has a BS in computer science. And last but not least, we have our moderator, Gene Quinn. He's a patent attorney and a leading commenter on patent law and innovation policy. He founded IPWatchdog in 1999 and since has twice been named one of the top 50 most influential people in IP. He's regarded as an expert on software patentability and U.S. patent procedure, and has repeatedly been recognized as one of the top IP strategists in the world. So you are in great hands with this panel. Back to you, Gene.
Great. Thanks a lot, Renee. And I always chuckle anymore when she says I'm an expert on software patentability. And I think that what it is it's easy to be an expert on software patent eligibility. You start with the presumption that no patent for you can ever be obtained, period, the end, until you fight like hell. And we'll talk a little bit about that with some of the examples I think we have on store for today. Hopefully things will get better. We will have a robust conversation about patent quality and what can be done. And I think since we have a lot to cover, I'm going to jump right past the opening statements and right into what we're going to spend really a big chunk of the time on here today. And I'll bring everybody into this and want to get everybody's thoughts on this. And what is the problem with patent quality? What's going on here? And as we are going to talk about this, I'll momentarily start a poll question to get your take on it from the audience. But Savon, maybe we start with you. What is the problem with patent quality today, in 2025?
Excuse me, the thing that I've been seeing is that you are seeing patents that when you look at it and you read the spec and the claim, you go, huh? How did this get through? So I think, and that is for me one of the probably the main issue is that we are getting patents allowed and through the system that just kind of, again, it's a moment of it just doesn't make sense. A lot of times it's based on what my personal knowledge of what the art is in that particular technology area. And so, that's for me just looking and seeing what's out there from us, Canon USA getting patents. Obviously, the goal there is to I don't want any of our patents to fall within that group. So then the challenge for us is to make sure that we don't end up with a what patent.
Yeah. Yeah, and I try not to make fun of patents anymore like I used to when I was younger in my career, because I know there are people behind it, they're innovators, they're ideas, and whether they qualify for a patent is a secondary question to the fact that it is an innovation. It is, innovative, I suppose. Having said that, when I look occasionally, and usually during the summers, I have a little bit more time to reflect on what's going on. And I look and I just read the Gazette and see what's getting issued. And I saw like last summer like a hookah pipe, and I use this example all the time because it's a hookah pipe with integrated radio gets patented. And then I know some of the rejections that you all are dealing with, and it's like, how can that get patented? And other things dealing with facial recognition and tangible systems and data and memory and cameras be considered 101 and not patentable at all. And that frustrates me because patent quality, I think, is uneven. And that's my opening thought on patent quality. Clint, let's bring you in here now. Don't feel like you have to address anything that's been raised so far, but where do you see the problem with patent quality?
Well, I think it's with examiner variability and also the large number of inexperienced examiners at the patent office. By the increase of filings over the years, there's been a lot of, new patent examiners. And I think Dennis Crouch had something that was issued, not too recently, but, looked at the examiners that have 10 years of experience compared to the examiners that have 3 years of experience.
Mm-hmm.
And patent examination is not an easy job. Searching is not an easy job. And it's done under time constraints. Any patent that ends up being valuable, they're going to spend a lot more time searching for prior art, than the examiner had even close to, especially an examiner who doesn't really, understand the art that well. And, a lot of times they're taught kind of to issue, a certain amount of rejections, and then, once it gets narrowed enough, then they'll issue the patent, and they might not have the best art in front of them. So someone who knows the art really well, like Savone, can look at that and say, oh, that's definitely, the feature that was considered, to get past, inventiveness is out there. So it's just, I think, a knowledge gap.
Yeah. Yeah, and I think and maybe Jim, we should go to you now, since examiners have been discussed, and I know you were a examiner once upon a time before you left to do the work at IP.com. What say you about patent quality? But whether you want to put your examiner hat on first, or you want to put your outside hat looking into the office.
Well, it's funny. I've seen it from so many different perspectives. And as put on my examiner hat first, I would reiterate what Clint said. I think anyone that's done the job will tell you that the amount of time that they have to work on a case, they wish it was longer.
Mhm.
And I think that's true universally across the board for all examiners, that just the more time that you have to devote to the case, the better prior art that you can find. I'm not saying you can't accelerate some of these things with artificial intelligence. In fact, you can, but it's still just really a numbers game in terms of how much time do you have versus the amount of office actions that you have to get out. And then from the other perspective, I've had a chance to see it kind of on the other side of the fence as an inventor and with the patents that we get here at IP.com. And it's definitely a different perspective. I mean, and it's caused me to really appreciate the role of in the inventor in making sure that you get good claims in your issued patents, and really caused me to kind of reflect back on my time as an examiner and think that, well, there's really two sides to this coin.
Yeah. And we've been chatting in the green room now for about 45 minutes, and so maybe I'll jump ahead. I kind of thought this might come up at the end, Jim, but what you and Clint talking about the examiner burdens and the time it takes and in that sort of thing. I wonder whether number one, I do think artificial intelligence searching is gonna streamline an awful lot of that. But do you suppose that the problem with patent quality is what we were talking about in terms of I think how I said it was examiners frequently will use the same 5 to 10 references, regardless of what the invention is. And they make those, and it's not to say that they're irrelevant references, they're relevant, but they try and make them fit to everything that comes up within their art unit often because they know them so well. And is that because of they don't have enough time? And can AI help all of that? I think the answer is yes, but I'd like to hear, maybe we can go around and Jim, let's start with you since you were an examiner.
Sure. Well, I think one thing, the semantic search technologies, like the kind that we work on at IP.com, make a huge difference in this process because you can just like copy and paste a claim or a couple paragraphs that are key and get some good art back. So I think part of it is that when you're relying on older search techniques like Boolean only techniques and having things all sorted by date, it's easier to kind of have this, and you brought this up a little bit earlier, Gene, this needle in the haystack problem, where
Mhm.
the best prior art is just buried amongst others if you don't have any way of accounting for how relevant it is to your search query. So I think that the AI is going to go a long way to helping solve this problem because it's going to be able to help you prioritize your review on the art that's the closest first, whereas kind of how you had to do it in the past was that wasn't really possible.
Mhm. Yeah. So Chris, I know I made you sit there and wait to talk for a minute, but the benefit of doing that is now you get carte blanche to either address anything that anybody else has brought up so far or to take us in a new direction.
I mean, just to build off of, I think Clint mentioned that usually when these are submitted, you've got an examiner that, even though they're in a field, they're not a subject matter expert in the same way that the applicant is. And that's really where the semantic search is going to come into play. I think that helps democratize the whole process of becoming a subject matter expert. It's probably a lot of the reasons that these quality problems exist. Being able to search based on meaning as opposed to having to have a well-curated list of keywords is going to go pretty far, I think, as far as mitigating these quality problems in the future. But I think that does create the cause for a lot of them currently.
Mhm. Yeah. So I just published the results. I think what these results suggest is we have a very honest audience here. Because I would have thought that we don't have a standardized process would have been one of the highest, if not the highest, and it's second. It's closely behind. We rely on expert reviews in order to determine and assess patent quality. Um, Thoughts on this, gentlemen? Anyone?
I mean, I'm not that surprised because I do know, talking from a bunch of different colleagues, especially for in-house, that there is some sort of, especially again for in-house, that there is some sort of quality assessment going on from a patent portfolio management system. So I'm not too surprised by that. Maybe just that perhaps the external legal counsel is as low a percentage as what it is, because I would think maybe some rely on external counsel for this more than they do. But overall, not too surprised.
Yeah, and I suppose Clint, if you're relying on your external legal counsel so little for this, what does that say about? I mean, do you get the sense that attorneys are still just trying to get any claim that they can and are maybe not really tuning in with what's valuable for the client?
Um, I think it kind of depends. There's so much price constraint on drafting, and a lot
Mhm.
of companies are just trying to compile patents. They're not necessarily going to litigate. They don't file a bunch of continuations. So, they try to essentially use outside counsel as little as possible because they have budgetary constraints from above. Most of the time, if we're doing this type of analysis for clients, it's usually like a smaller or mid-sized client. Large clients, are not going to send this stuff to outside counsel because they honestly, it's a difficult and expensive process to do, and it's relatively subjective at times. Like if you're looking at this a claim and you're like, is this claim obvious? And you have a reference that discloses, like both of the features, can you come up with convincing reason to combine them? Likely. Can you get a convincing expert in front of a jury to do it? Maybe not. Can you get an expert to convince the PTAB? Probably. So
Yeah. Yeah. Okay, well, let me push to the next slide, which is the other side to this coin is, well, why does this matter really? What is the evolving role? And I think, we've been touching upon that. And Chris, maybe I'll go to you first on this question. Um, how do you see the role of patent quality evolving within the industry?
I think what we're going to see is a lot more use in specifically transparent types of AI and taking over at least the first stage of evaluating these patents for their quality in various methods. What's incredibly important is being able to, when you're using a system that utilizes AI, is making sure it's transparent. You can understand why it's providing the scores. It's repeatable when it provides the scores. But as we get into the future of patent quality, as AI becomes more prevalent, these using manual evaluation processes that can be easily biased or just hard to repeat, it's going to, I think, decline over time.
Mm-hmm. So, Savon, your thoughts?
Yeah, when I saw this chart, the two items that immediately I focused on were the second, the high patent quality, and the subjective assessments. For the subjective assessments, yeah, I mean, I may have a case where one of my attorneys will rank a case as 4, and then if I just want to get a second opinion and I give it to somebody else, they may rank it as an 8. Just as an example. So then I now need to spend the time to step in and figure out, is it a 4, is it an 8, or is it really something else? Where I can see definitely AI was going to remove that and improve the overall process time. And then also from a quality standpoint, obviously the better quality that we can get, from a cost standpoint, we can focus resources on that as opposed to working on a case that may not necessarily have much of a licensing opportunity. So again, I could see AI definitely helping streamline that particular process.
Yeah, and I think it'll also streamline the process of deciding what to keep, what to continue to pay for maintenance fees. And I see a lot of role. But Jim, you're the expert here on what these tools do. You're an inventor on some of these tools that you guys create. What do you see?
Well, I would say that it can give you a broader picture. So, for example, one of our technologies related to scoring patents can account for 14 different objective AI-based metrics related to the patentability of the idea. And they can account for things like, say, forward citation analysis, classical looks at different classification codes, things that people would do in the course of a manual process, but have it be automated. And they can also look at things like more advanced semantic-based analyses that are not as possible just for a person to do on their own. And you can kind of merge those together and have a really useful report that can help you understand the relative quality of a given asset that you have, to ultimately help you with those decisions like getting things granted, or potential litigation candidates. That's kind of the way that I see the technology, which is letting you paint with a broader brush.
Yeah. So on that point, we have a question that just came in, and to ask about whether or not IP.com's AI is useful for a patent assertion entity, or perhaps a litigation funder who may be evaluating whether to invest in an enforcement campaign. And it would seem to me that yes, right? I mean, when you're trying to decide whether this is a quality asset and what the warts may or may not be, the generative AI is going to be very helpful, right, Jim?
It can certainly help with that. It can also help you identify candidates of interest that you may want to approach in the course of looking to enforce your patents. So it can almost do like an automated evidence of use in addition to providing the AI-based metrics themselves.
Mm-hmm. Okay, great. So, all right, we've been going for a little over 20 minutes. So let me just, and we've already had our first question, but want to encourage you all from this point forward, if you have any questions, now that we kind of got what we're going to talk about out on the table for you all, if you have questions for the panel, please submit them in the Q&A box. I'll be monitoring that, and I'll try and weave in as many questions as you have. And I can see that we have a very active chat going, which is great. If you have questions for Renee and her staff about technical issues, slides, what have you, you can go to the chat. And if you want to just chat amongst yourself, as many of you are already doing, please go ahead and use the chat feature as much as you would like. So let me push to the next slide to get a little bit more out for what we want to talk about, because this is about the challenges, and we do have another poll question that's relevant to this particular question. And the poll question is going to ask you, what is your biggest challenge in managing patent quality? Clint, let me start with you on this one. What do you think is your biggest challenge, and or the challenge that you hear most often from your outside clients?
Well, so I think one of the biggest challenges is for smaller companies to, perform a freedom to operate analysis, in a in a in a way that's cost effective. Because essentially, a big company can do an extremely thorough analysis with attorneys and can have somebody reviewing every patent that's of interest. But frankly, a small company's not going to have that capability. And a lot of times you hear from, a company that's at startup stage, you have a talk about the risk, you even identify a couple of patents that they have to worry about. And, they get to the point where they're just like, you know what, this is not the way for us to spend our money right now. We'll deal with it later. And of course, you hear back from them years later, if they're successful, that they want, a larger analysis on these patents and see how they can license them. But if they, are not successful, of course, it's not an issue.
Yeah. So Vaughn, maybe from your perspective inside, what is your biggest challenge?
It's basically kind of like, again, probably maybe the first two bullets. It's the subjective versus objective comparison analysis of the particular case in question to determine what the particular quality is. And then looking at the poll questions, if I was to answer the poll question, the two that I would have I would choose between would be identifying high value and managing portfolio costs. Because really for us, the main driver for the evaluation is the portfolio cost, because the business unit that owns that particular patent is responsible for the cost. Therefore, they have to budget. And so then the question becomes, Do you want to spend your money on a low evaluated patent, and as opposed to focusing on the higher evaluations? But obviously, you need to have a good evaluation done in order for that that cost analysis to be done. So it's really something that you want to try to get to some sort of objective analysis, and so that's kind of probably the main challenge that that my team faces.
Yeah. And you put your finger on the number one and number two answer from the audience. The number one was managing portfolio costs, not by a lot. And on the heels of that was identifying high value patents. Although to be honest, um, all of these got quite a good amount of love from the audience. So, Chris, your thoughts on the poll? Does this surprise you in any way, or is
Not
this
at
what you
all.
expected?
I think it's pretty much what I expected. All of this, at least in my experience dealing with clients, is more or less related to, in a lot of cases, volume. And specifically, bullet point 3 on the slides talking about they're lengthy, resource intensive, and especially when a team is in charge of managing a portfolio of hundreds or even thousands of patents, trying to find those needle in the haystack patents where it's either worth going after additional monetization efforts or there's a litigation risk that you weren't previously aware of. Most teams just don't have time to find the litigation risks in their patent portfolio or finding the high value patents. And I think that's where the automation comes in here. I think that's one of the main challenges that I see in the market right now.
Yeah, yeah. Before I give my thoughts here, Jim, I want to just let you react to anything that's been said so far, or the poll, or however you like to take it from here.
Sure. I think identifying high value patents is definitely an interesting one to me. When I think about our own patent portfolio here at IP.com, that really kind of comes off the page because there's so many different things that you can invent, and there's so many different directions that you can take inventions in. You can decide to keep something a trade secret to get a competitive advantage. You can decide to file a patent application. When you're doing that, you can do a really broad kind of omnibus patent application and file a bunch of continuations off it, or you can do a very narrow patent application that's directed towards one particular technology. There are so many different roads that you can take to protect and monetize your intellectual property that I think identifying high value patents is really important strategically.
Yeah, and if I can just follow
Sure,
up
go
on what
ahead.
Jim, if on what Jim said with identifying high value patents, which is one of the, like I said, which is one of the two that I would have chosen, depending, is, and going back to the objective versus subjective is, well, what do you look at to determine if this patent has a high value? Do you focus on, is it in a product that's going to be sent out to be sold? Is a high value patent considered one that the claim set is such that you can prove infringement? Getting to Jim's point, maybe it might be a high value, I call case, not necessarily a patent, because, maybe the claim is very strong, but I can't really prove infringement. It might give me a competitive edge, so maybe I keep it as a trade secret. So again, it may not be a high value patent, it's a high value invention. So those are, like I said, the different factors. And again, it now goes back to, if you're subjective, one person may put a higher value on it's in the product versus someone else may put it on, hey, this is something that is easily shown for infringement and there's no design around. So I think, Jim had brought up some good points about, with respect to the high value patent analysis.
Yeah. So my final thoughts on this, and not, I shouldn't say final because we'll loop back here, but we have a couple more slides I want to make sure I get to so we unfold the entire conversation. But I guess, and almost embarrassed to say this because I've been focusing on AI as a way to streamline, and in a lot of ways, looking at, for example, patent prosecution or whatever, however you want to do it, whether it's the representative and the examiner getting on the same page, whether it's the litigation funder and the attorneys and the patent owner getting on the same page and deciding, okay, these are the assets that we're willing to fund, these are the ones that have the best case of infringement. It can be, but really what I've been focusing on the ends and not the means. That what the means are doing, I think, is what Savan is pointed out, is taking away the bias, or if there is bias, it's all the same bias, hope every time. and then you can address that, like, so if you, Savon, look at this patent and say, okay, this is a 6, and one of your people says it's a 4 and it's an 8. Okay, well, now you've got to get everybody on the same page. And similarly, you could, if the AI were to do it wrong, but you could train the AI on that. That's one of the beautiful pieces of this. So the technology can really facilitate more reliability on the data, I think, and understanding that this is what it really means. This is what's really out there. Now, where do we build from there? So I just want to throw that out there. Let me get to the next slide here, because this is something that we decided to add late in the game here, about the inevitability of AI having an impact on what is likely going to be patentable moving forward in the future. Do I have a volunteer to take the lead here? Clint, you're smiling, I think. So
Yeah,
maybe I'll just go to you.
Yeah, kind of what we were mentioning the pre-call. I think it'll come up in litigation at some point. An expert will, introduce AI and, show how, almost provide, a motivation to combine within, showing what's capable with AI, and then there'll essentially be law that develops after that. But I don't necessarily see it impacting it on, the patent office, patent, procurement level until that actually happens. And you would think that, it takes a few years, for patents that, were issued when, for example, OpenAI came out to, end up in litigation. So I think it'll be extremely interesting, but I definitely think it will have an impact.
Yeah, I do too. But Jim, your thoughts as a former examiner?
Well, I think probably the biggest impact ultimately, and this will take some time to Clint's point, is going to be that it's going to raise the level of ordinary skill. And that's an important consideration when you're doing obviousness analysis, because something that might have only previously been discoverable by, say, a PhD in the field might become discoverable by an undergraduate who's utilizing a generative AI or a semantic AI as part of their analysis. And that's ultimately going to raise the bar for patentability and make it, harder to get patents, which could potentially be problematic in some respects. But also it's going to be kind of, I think, to the point where it's like you would expect someone to use a calculator. You're going to expect someone to use generative and semantic AIs in the future.
Yeah. Yeah. Savon, your thoughts here.
Yeah, I agree with both Jim and Clint in terms of the potential impact on the patentability. Jim's with the ordinary skill and the art. Yeah, that's probably gonna definitely morph, for lack of a better term, over the years as AI starts getting even more prevalent than what it is now. So that standard, again, right now it's questionable. What does it still mean? With AI, I think that may just open up some more questions. But I do also see, just from a patentability standpoint, that you potentially are going to get better in some arenas, some areas, better patentability searches. That it's not just an office action, but perhaps even internally, that all of a sudden maybe a decision to file on something where you may have filed on it 5-6 years ago based on a manual search, and what came up under AI, the AI may have better art, better references, that maybe that now changes that. Again, what you would have filed on 5-6 years ago, maybe not now, just because better art was found, not that there was new art that came in between, but that there was just better art. So I can see where the patentability challenges are going to be maybe upfront in terms of filing decisions, and then on the back end in terms of what kind of office actions and references you're going to need to deal with. The interesting thing I would like to see, or that I would think about, is what happens if especially for those that do foreign prosecution, is, well, what happens if the US patent office decides they decide to go AI, but the Chinese patent office doesn't? So what kind of disparity, or disparities are going to be between patent offices, where if one uses an AI tool to get the references and another one doesn't? What kind of consistency are you going to get in terms of references being cited against basically the same claim set?
Yeah. And before I give you my thoughts, Chris, do you have anything to add or?
Just to basically reiterate what's been said already, I think with AI becoming the new benchmark for ordinary skill, as well as being a tool for the democratization and enablement of better IP searches, both before and after something's been filed and possibly patented, it's going to really just become increasingly difficult to compete with companies that are making full use of these tools as time goes on, if you're not already using them yourself.
Yeah. Yeah. And I'm trying, it was a very active chat, so I'm not able to follow all of it here. So if you do have a question, please make sure to put it in the Q&A. But I see here Milton asks, so judges will say that you can't enforce your claims because AI would have thought of it. And I'll share with you what I said in the green room while we were coming in. I have every confidence that the Federal Circuit and Supreme Court will get this wrong initially, because that's usually what they do. And then we have to sort it out over a period of a decade. With eligibility, it will wind up being 2 decades before we figure out what we all probably know, if we're honest with ourselves, what should happen. But I do have every confidence in judges getting this 103 stuff wrong, because if you recall, KSR came out in 2007, and Bilski then went up to the Federal Circuit shortly thereafter, and it was 2011 that the Supreme Court issued Bilski, and then we went on this long, strange journey of 101. So we don't really know, I think, the full impact of KSR on a whole host of the most important, valuable inventions. I'm thinking biotech and I'm thinking software, which those two areas probably account for 80+% of innovation that's going into the patent office today. So I don't think we really know what KSR means, because so many of these inventions are just getting no patent for you without any application of prior art, let alone even inquiring whether it's really innovative. And I understand under 101, there is the question, is this well-known or routine? It's not about innovation. That's about might as well be using a divining rod to find water, like just take a stick and hold it out in front of you like they do on these documentaries, and they try and find water. That's what they're doing with 101, with the conventionality stuff, because there's only one way to know whether something's new, and it's to do a prior art search. So
Hey,
go ahead, Simone.
I'm sorry, Jen. I just wanted to follow up on, your the comment about and the question about, are we going to see something where it's rejected because, AI could have come up with it? Well, let me pose a hypothetical. Right now, I'm still seeing rejections where the examiner is saying this could have been done in the human mind.
Yeah.
Is it that far of a stretch to think that at some point, can it be done by the human mind, will be removed from the office action, and can it be done by AI?
Well, and they don't even ask the whole question honestly, right? It's like, could this be done by a human mind in any kind of relevant time frame? It's like, yes, like if we lived as long as a robot lives, and the answer, getting a answer at some point in time, 100 years from now or more, would be relevant. But if you're trying to like track an incoming missile, and it's trying to evade you, and you're trying to intercept it, I mean, you're talking about seconds matter. And let's just be honest, a human mind couldn't do that.
Right.
You just can't do that. And yet there have been, in the military context, I know specifically cases where that has come up, and it's like, no, this stuff is really complicated. It's really complicated to get the machine to do it fast enough. There's no way a human can do it fast enough. So we see a lot of this craziness. And then the other craziness, specifically with obviousness, is you're starting to see, and you probably have seen this for a little bit, people just letting AI run wild and say, make up every possible combination of these elements, and then they try and publish that in a database as if then that will defeat the patentability for anything that possibly could work later on down the road. And that just makes no sense. I mean, that's the needle in the haystack, right? It's like, so I got to go through all this to figure out, knowing that most of it doesn't work. It's put together upside down. It would blow up if it was ever turned on. It would do the exact opposite of what's intended. And somewhere in there, there's a pony. So we have a lot of issues to deal with on the use of AI from an offensive standpoint, or maybe that's really more of like from a defensive standpoint, I guess, to prevent patenting. But I do think that everybody in the panel is exactly right, that at some point in time, if you're not using AI as a tool, you're going to be out to lunch, because since it is a tool, it's going to raise the ultimate output. I think is going to be to raise the level of the posita. Thoughts and comments on any of what I just said, gentlemen? Clint?
Yeah,
I I actually just you had me thinking on KSR, and one of the rationales on KSR is simple substitution with a predictable result. I could see a litigator, because litigators are clever, taking, for example, the filing dates 2020, taking a model that was available in 2020 and saying, would it been, what are some predictable solutions to, this, and then having that output and put it in front of a jury.
Yeah. I mean, I think we know this stuff is gonna happen, and predicting that it's gonna happen and I suspect that most of the people on this particular webinar are prosecution-based folks or innovators or business people who are trying to monetize the innovations of your companies, more on the front end and less on the litigation end. But we have to know what those litigators, we have to be able to predict what the litigators are going to do and the arguments they're going to make in order to tighten things up on the front end and take these arrows away from the quiver. We do have a quick question here. I think we can get to this very quick. Do you think innovators are not doing sufficient prior art searching before filing? My answer is going to be definitively yes. I mean, I know some don't search at all. And I just have never got that. What do you guys think? Is searching enough, not enough?
I think it's essential to search because, like, to the point you made at the very beginning of the call, Gene, the name of the game is the claims, and you don't want to have your head kind of stuck in the sand when it comes to prior art. If you can find it ahead of time, you can draft appropriate claims to get around potential future office actions, reduce the overall pendency of your patent application, and really help you kind of inform the prosecution process with your invention disclosure statement and put you in a better position, ultimately get a stronger patent with the best art on the record. I mean, I see so many advantages to searching. I just can't imagine anyone advising their client that it's a great idea not to do any searching.
I'm totally with you. I mean, because I also fundamentally don't think most of these 101 cases that we're seeing play out in the courts are because the innovation should not be patented. I think what it is the law changed. People were going after a different target, and they missed the target that's kind of moving, right? But you have to know what the target is. If you don't know what the target is, then you're going to write things in a way that does accentuate the positive. And I mean, to me, that it's so critical. So I think oftentimes it's when you don't have enough disclosure, is it because there's not an invention there, or because you didn't put up enough time and energy to describe the invention? It's so often that will be solved if you know what else is out there, you know what the search is, and you can describe the white space that you see.
Yeah.
Go ahead, Clint.
I've had clients over the years that do a very quick search in-house, and then they send you an application to draft. And those applications always take a lot more office actions to get something allowed. And you end up with some claim scope that's kind of like, it's in between where how you would have described the idea and had, written description support for it if you would have known about it before. So if you know about it before, you don't just draft a good independent claim that cover it. You can draft lots of really good dependent claims. And you might describe similar features in your spec that you would put in dependent claims, but the amount of thought that goes into drafting good claims in view of art, is so much more beneficial if it can be done on the front end. So having really good dependent claims makes your patents so much stronger. You could have a broad claim that maybe gets invalidated the PTAB, but if you also have a bunch of really good dependent claims, it makes it more likely that the person you sue is going to settle or license.
I mean, I agree with Jim and Clint in terms of I don't see a downside to searching. Because, you know, if you don't and you don't really know what's out there, you kind of, you know, putting together a claim set kind of in the dark. And, you know, the last thing you want to do is get an office action that's directly on point that you could have essentially, if you potentially have found that reference, avoided that. Now, I do understand there are going to be situations where no searching is you're not gonna have time. For example, if, you know, one of my business units comes to me today on 3/27 and says, oh, by the way, I'm going to a trade show on 3/31 and we're going to disclose this entire invention. Yeah, then obviously I'm going to just file with what they had. I'm not going to worry about a search. Now I may do a search after the filing, so that if we do need to, you know, somehow massage the claims a little, we'll do that. But again, I don't really see a downside to searching.
Yeah. No, I agree. Chris, any thoughts before we move on?
I would just back to what you said about how the initial search absolutely is not happening enough or not at the level it needs to happen at. 100% agree with that, especially with experience working with a lot of companies in the marketplace right now. And then towards what Clint had mentioned as well, where when only a partial search or no search at all happens, when he gets sent that application, it takes so much more time to get it developed into something that's usable. I think with the tools that are available at hand, where it's easy for anyone to get in there and do a much higher level search than what they could have done 5, 10 years ago, I think it's inexcusable for that search not to happen initially, unless, of course, like Savone mentioned, there's just something time sensitive. You don't even care about doing the search. You just have to get an application out there to get something in the marketplace.
Right, right. When rights are in play, you have to do what you have to do.
Yeah.
But you know, if the rights are not in play, and I think the wrap up here is that Richard followed up with his saying that his experience is that oftentimes innovators just aren't willing to pay for the pre-filing searches. I think that's right, but then you're going to wind up getting like what Clint described, a long, more arduous, more costly prosecution oftentimes is what's going to follow. And then the rights you're going to get are not going to be as good as they could have been. And you know, it's not a zero-sum game where there's a winner and there's a loser. You know, if you make a certain choice on this end, there will be consequences later. So it might seem cheaper here, but it'll be more expensive later. You know, and that old saying, you know, don't be penny wise and pound foolish. You know, and a penny of prevention is worth a pound of cure. You know, all those are just they're not old sayings. What they are is they're descriptive. They're descriptive of what we see in our space and what people see all over the place, I think. All right, good conversation, guys. I think we have one more slide here to get to transforming patent quality with AI insights. And we have a couple more polls. Jim, I'll go to you first and let you tell us what you want to lead off here with this slide as I launch the next poll question, which sort of relates to this.
Sure. I just wanted to get a little bit, because I saw some questions in the chat too, into the kind of factors that we can measure using AI. So we can address things like overall strength, risk of litigation, monetization potential, value to new technologies, and patent quality. And in like one of our reports, those are kind of the 5 major factors that we consider that you can score and rank to figure out where patent falls along those different vectors. And those factors consider inside them things like forward citation analysis I mentioned earlier, where documents are being classified, semantic analysis using our AI engine. And those are some of the things that you can glean by using AI insights on a portfolio. And I just wanted to go in a little more detail. And I should mention specifically, we do have a white paper that's available for how we actually calculate all the factors. So I don't want to go in too much detail on this call, but anyone that's interested could download our white paper.
Yeah, and we can make sure that in the follow-up email that you all get, we can include a link to where you can get that downloaded in case you are interested. So Savon, maybe I'll go to you next with the poll question showing. I suspect I know what you would pick, but what would you pick?
Again, it would be a tough choice between the first one and the last one, strengthening the portfolio and improving the internal patent evaluation. But I guess the way I look at it, if I do improving, that theoretically should result in strengthening the quality. But again, as I've said, you know, as I've been,
Yeah,
Surprise.
look at that. Yeah, yeah, there's a tie for that.
But
And that's
again,
what I figured you were going to answer because those are very related. They're interrelated in some ways, depending upon how you define the problem in your own mind. You would pick one over the other, but those are, I think, are the two, right?
right, right. And then again, as I've mentioned a few times during our time, is that for the internal evaluation process, in order to streamline that, the more you can remove the subjectivity and lean towards the objectivity, I think the quicker and the more efficient the evaluation is going to come. And also, again, from a cost standpoint, it's going to be a little cheaper, because obviously you need to charge your time to something to do this evaluation. And then I think that would then again lead into strengthening the patent portfolio quality, because then it comes down to making decisions. Do you want to spend the time filing? Do you, when the case, issues, do you want to spend the money, the issue fee to get it issued? And then obviously there's maintenance fees. So I think a streamlined patent evaluation process is necessarily leads you to potentially a stronger patent portfolio strategy.
Yeah, and on some level, all of these are related. I didn't mean to suggest in what I said that if you picked one of the two in the middle, increasing licensing
Right.
revenue or reducing risk, that those are wrong answers. But
Right.
based on what Savon was talking about in terms of managing the portfolio and investing and making sure you get good quality, non-biased data to make the right decisions, however you define that problem would lead you, if that's your top concern, to either the top one or the bottom one.
I mean,
Good.
I think even the top one, you start with the bottom one and you get the top one, and I think the top one also necessarily leads into increasing license revenue. Because
Absolutely.
if you got a strong patent portfolio, that gives you, more things to play with, for lack of a better term, when it comes to whether, what do you want to do with your portfolio?
Yeah. Clint, your thoughts?
Yeah, as outside counsel, one of the best ways that we can help our clients is the money that they're spending on us is towards assets that are going to be valuable to them. So if these tools can be used to have our clients know, okay, we filed this application, we don't want you to spend a bunch of time trying to get the broadest claim scope as possible. It's not valuable. We want a patent, but just call the examiner, see what the examiner is willing to allow, get something, quick, as opposed to the other end on it. This is an unreasonable rejection. This patent's really valuable to us. It's worth the money to fight for it. Let's file an appeal. Let's file 5 continuations. If we can, have that information, we can serve our clients better.
Yeah. Yeah. And Chris, your thoughts here on what matters for the insights, the AI insights.
Yeah, just to echo what Savon has said a number of times during the discussion here, is the subjective, versus objective measurements of patent quality. Normally, when talking to various people in the industry, the fourth option there about just maybe not even having a process to evaluate the quality of these patents is usually the main issue, and it's because of that difficulty getting the subjectiveness out of the metrics, of the way they score them. That's prevented a lot of companies from implementing any sort of process here. I think that the use of these tools here that can do it, well, one, much quicker than a human can, but also do it without the bias that is pretty much impossible to eliminate with a human doing this process, often leads to building a better process for IP evaluation, makes it a lot easier, a better foundation, so it's easier to build that process out as time goes on there.
Yeah. All right. I want to launch the last poll question here, which relates to this question as well about insights from AI. What would you find most valuable to having an AI powered patent quality tool? And Savon, our predictor here, I'll go to you first, Karnak, and ask you.
Again, if it was me, based on what's kind of where our focus is, it would be the first one. But again, and if I had to pick a second one, again, it would probably be the second, the competitive intelligence on peer portfolios. Just again, because I think understanding what's out there definitely helps when I start creating and drafting. If I know what's out there, I know what road map to take to try to get my claim out. So I would probably go automated patent scoring and quality metrics. Again, for us, that would be my first one.
Clint, what say you?
Well, I generally agree with most things that Savan says, but I think that AI-driven licensing and monetization insight could be extremely helpful, for clients deciding that, all right, we filed this patent application years ago. It didn't end up being that important to, our business. We didn't end up going forward with it, but they don't necessarily know, if there's value outside of their company. And I think if you're not taking, those factors into consideration, you're not really getting the best spend for the best return on your spend for patent prosecution.
Mm-hmm. So I'll end here and I'll share the results. And once again, our resident psychic here, Savone, was right on the money based on our audience. It's like you're tuned into the audience
Well,
here. You're in the same
Gene,
frequency.
yeah, Gene, I need to leave. I got to go catch a flight to Vegas. So.
No problem. Yeah, put it all on black.
Yeah.
Yeah. So excellent prediction here today. But these are all. It sort of depends upon your use case to some extent, I suppose. Although I could make a case that even if you were looking at AI-driven licensing and monetization insights as being the most important, what for me, I would look at this as I need to know without bias, with some objectivity, what is the score? What is the value? What is the how do you rate these different assets first? Because you may have assets that like they're infringed out the wazoo, but if the claims or the patent itself isn't bad, the spec is not great, the claims aren't that good, or maybe the claims have some one-on-one issues, that can really influence your decision making. So again, I think it's probably how are you looking at this? Because all of these in some way relate to one another, but you just, I don't think, can afford to invest in monetizing or trying to monetize or license assets that are not high quality assets, that when you pick them up, if you were going to give a grade on this, it's got to be an A asset, maybe A minus at worst, because if you're going to the B's, I always say this, when I first started my career, we did litigation. I worked at a firm that did litigation across the board, and they offered contingency. The only way you could offer contingency representation is if you knew with 100% certainty that case was going to settle. And the reason is because the case is never going to look as good as it does the day you sign up the client, right? So there will always be warts. So if you're picking up an asset and it's a B minus asset or a C plus asset, or even if it's a B asset on day one, once people start shooting at that, it's not going to go up. It's only going to go down. So knowing which those assets are, I think, is so critically important. Of course, all of these, then whichever one you think is most important, I think the other one is that, okay, so then this is most important, which leads me into the next question, which is, well, who are my targets? Who do I approach? Or maybe you look at it vice versa. Jim, what are your thoughts on this?
Well, I mean, I think it's an interesting question, Gene. I mean, in terms of in terms of kind of who you can look at, I think that for targeting a patent portfolio, I think that can be an interesting question. But I mean, ultimately, it comes down to how you want to prioritize your enforcement strategies.
Yeah. And Chris, any thoughts on this before we move into the closing remarks?
I probably just want to stress, I know we voted on different features that would be more valuable. When you're using an AI tool that can do these kind of analyses much quicker, you really don't have to choose between these. A single report can tackle all of these bullet points at the same time, which is really important because 100% can understand competitive intelligence being a primary concern when initially going to look at the analytics around a patent. But what I typically find with users or with people I'm talking to is that monetization insights become a higher priority sort of later down the road. The priorities kind of shift as they get further into their portfolio analytics. So being able to have a single one-stop shop where you can get all these at once means that you don't have to keep going back and redoing this analysis over and over again. So I just wanted to keep that in mind.
Yeah, no, absolutely. I think that that's very, very important. All right, so that was our last poll question, and now we are ready to move into the home stretch here. And so gentlemen, first, thank you for being here. Really appreciate you being here. Um, why don't we go? Well, Chris, I'll give you the first word in the final round here. If there's one thing that you hope people will remember today, what do you want them to remember?
I really would like people to just remember that it is possible to do these analytics quicker, that this process, the use of these AI tools is going to be able to democratize this typically very intensive process that takes a lot of training. It's going to democratize it, make it accessible to pretty much anyone starting at the inventor level and going through assisting people like Clint and Savone who have extensive knowledge and experience in the industry. These tools are a great first pass or additional option for pretty much anyone that needs to get involved in this to help them understand better what's happening in the marketplace much quicker.
Great. Thanks a lot, Chris. Clint, your final thoughts here today.
Well, I would just say that, you know, these tools will help supplement your patent attorney and make your patent attorney better. They won't replace your patent attorney, you know, as everyone talks about with these AI tools. You know, it allows us to do a better job, and you know, there should be always communication, you know, when you're using these tools with, you know, with your outside counsel. It's going to make them do a better job.
Great. Thanks a lot, Clint. Savone, before you get on the plane to Vegas, what do you want people to remember?
Just kind of the theme that I've been talking about is it looks like since a significant number of the attendees already have some sort of evaluation process in place, it's my recommendation would be just try to make it as objective as possible to kind of streamline things, and whether that is just improve on what you've got, the human element that you have going on right now. If you want to just rely 100% on AI, or as Clint indicated, you know, maybe a combination of the two, because you always want to have, I think, the human element in there. So just, you know, do something that kind of streamlines it, and so that you get maybe a little better ranking at the end. Especially, you know, when you go back to the client, whether it be in-house for a particular business unit, or if you're, you know, if you've got clients that you're giving them the best recommendations for their money.
Yeah, great. Thanks. And Jim, the final word goes to you.
Oh, thanks so much. Well, I would say that the AI is here right now. It's ready to help you with your analysis. I mentioned that we have 14 different factors that can objectively assess a patent or patent application, and you can incorporate those in your process. And just to build on what Savone and Clint said, these are certainly not mutually exclusive with doing a manual analysis and having the expertise of a patent attorney or patent agent to inform your process. And I would strongly encourage everyone to continue doing that as they begin adopting AI tools.
Yeah. Awesome. Great. Well, thank you. And Jim, one quick question. Are those 14, we had some people asking about those metrics. Are they in the white paper or described in the
They
white
are.
paper?
They're all described in the white paper. Yes.
Great. Awesome. I figured they would, but just wanted to put the pin on that because I know we had some people asking. We'll make sure everybody that wants access to the white paper gets it. I know we didn't get to all the questions in the Q&A box, and I think there were some questions in the chat box. We'll make sure that those get passed along and that you all get answers to the questions that you've raised. But that's all we have for today. We really appreciate you being here, but bye for now, everybody.